Welcome back. This is again Maura Leary with the Office of Government Ethics. In part one of this legal expense fund overview training, we discussed the background behind the new LEF regulation and gave a general overview of the LEF trust process, which we will cover in more detail in later trainings. Subpart J also allows employees to accept pro bono legal services under certain specific circumstances, and that is what we'll cover now. Next slide, please. Backing up a bit, employees needing legal representation for matters relating to their government employment may seek pro bono representation, that is, legal counsel which is provided without charge or for a reduced rate. This arrangement generally operates as an in-kind gift from a legal service provider, so they provide the services rather than money, such as a law firm, although there are situations where an outside organization may want to pay a legal services provider, like a law firm, to cover an employee's legal expenses. And I want to note that because these pro bono arrangements have a much lower administrative burden than legal expense funds, this approach is often preferable to the employee if it's available. Slide 21, please. Prior to the issuance of the legal expense fund regulation, employees seeking pro bono legal services could accept them only if the firm was not a prohibited source and the services were not given because of official position. Now, this approach had a number of practical issues. Many law firms, especially those in the Washington, D.C. area where many federal employees reside, did business with government agencies and were therefore considered prohibited sources. Heather mentioned previously that some big agencies that were particularly problematic were agencies like the Department of Commerce and Department of Justice, where almost any law firm might be a prohibited source. In addition, as with legal expense funds, the not because of official position concept in this context was confusing, since the employee would not have the legal problem if it wasn't for their government job. Now, OGE had the position that it arose out of the legal matter, but it is a confusing concept and it's worth clarifying. Next slide, please. So now I'm going to talk about how pro bono can be accepted under Subpart J, so how we've changed some of those problems and addressed them. First, I want to emphasize that this process, the pro bono process, is entirely separate from the legal expense fund trust process. There's no trust document, there's no quarterly report, none of that is required if an employee accepts pro bono services in accordance with Subpart J. Instead, this is a new gift exception, because the analysis for whether this gift exception applies is somewhat complex. Employees must consult with their ethics official before they accept pro bono legal services. This is a requirement in the regulation at 2635 1009C. As with legal expense funds, this new pro bono gift exception is limited to legal matters arising in connection with the employee's past or current official position. It cannot be used for matters that are primarily personal in nature. And we discuss a lot of these concepts and frequently asked questions in the Legal Advisory 2307. It addresses pro bono services in a lot of detail. Next slide, please. So generally, I just want to walk through this, this analysis process. Generally, it's a two-step process. The first step is that the ethics official needs to determine whether the entity offering legal services does not have interests that might be substantially affected by the performance or non-performance of the employee's official duties. Again, this analysis is tailored to and focused on what the employee is doing rather than the general work of the agency, as with the prohibited source concept. And we start there with the legal services entity, like the law firm, because if that entity has interests like that, the pro bono services can't be accepted and the inquiry is over. So, so we stop there. If the entity does not have interests like that, we move then to step 2. And the ethics official then looks at the specific attorney or attorneys doing the legal work and determine whether or not they meet certain qualifications. Next slide. So those qualifications that the attorney must meet is that they may not be a foreign agent, a foreign national, a lobbyist, or a person who has interest affected by the performance or non-performance of the employee's official duties. Now, generally, as I mentioned, if the legal services entity, like the law firm, doesn't have such interest, the attorney won't either. But it is important to make sure. For example, the attorney could have a personal Social Security claim unrelated to the attorney's work at their law firm before the employee beneficiary at the Social Services Administration. This is an unlikely circumstance, but it's important to confirm that this is the case. So I'm going to back up for a minute and talk about an example. So sticking with the Social Security Administration. Let's say that an attorney at a large law firm offers to represent an employee at the Social Security Administration in proceedings related to workplace discrimination. The ethics official needs to first determine, so again, step 1, if the firm has interests that would be affected by the performance of the employee's official duties. And I'm hitting this point again, but it's important. So as discussed above, the fact that if this law firm has litigation generally before the Social Security Administration as an agency as the whole, that wouldn't necessarily disqualify the firm from providing pro bono services to the employee. The key question is whether the specific Social Security employee that's seeking to accept the pro bono services worked on any of that litigation or performed any other duties that would affect the firm's interests. So assuming that that is not the case, then the inquiry moves more specifically to the attorney offering the services. And again, although that individual attorney generally wouldn't have interests affected by the performance of the employee's official duties, we need to confirm that that's the case, as we just discussed, and then also confirm that the attorney is not registered as a lobbyist, a foreign national, or a foreign. If the individual attorney meets each of these criteria, then the employee may accept the legal services. And I do want to make one final clarifying note on this. The regulation requires only that the individual attorney providing the pro bono services not be registered as a lobbyist. So accordingly, an employee may accept pro bono services even if another attorney at the law firm or the law firm itself is registered as a lobbyist or a foreign agent. Again, this is not uncommon with major law firms, so it's an important practical point that will help improve access to pro bono services for employees. Slide 25, please. Now, there's one other permutation of this, as we discussed generally at the beginning of the training. An outside organization may also pay a legal services entity to represent an employee on a covered legal matter, but only if it, again, meets certain specific criteria. So as with 501c3 organizations donating to legal expense funds, there was also a lot of desire from the public comments for 501c3 organizations to be able to pay for pro bono services. So we've created this, this additional layer where if a 501c3 organization, if an organization is a 501c3 organization, if it was established as a 501c3 organization more than 2 years ago, and if that organization does not have interest that might be substantially affected by the performance or non-performance of the employee's official duties, then that organization may pay a legal services entity to represent an employee. If the 501c3 organization doesn't meet each of those criteria, then the employee may not accept the pro bono services. And if they do meet that criteria, then the ethics official conducts the analysis on the legal services entity and the individual attorney, as we discussed in the prior few slides. So again, I'm just going to walk you through a brief example about this. Let's say that there's a 501c3 organization that focuses on employment discrimination, and they offer to pay an outside law firm to represent a DHS employee in a legal matter relating to an EEO complaint. The ethics official must start with the organization. So they determine first whether the organization is registered with as a 501c3 with the IRS, and that it has been so registered for more than 2 years. Then the ethics official must determine whether the 501c3 organization does not have interests that may be substantially affected by the performance or non-performance of the employee's official duties. And then once that ethics official has confirmed all of those requirements of the 501c3 organization, they move to the two-step analysis we discussed, determining that the firm doesn't have interest affected by the employee's official duties, that the attorney does not, and that the attorney is not a lobbyist, foreign agent, or foreign national. So there are a long list of criteria that are required, but if each of those criteria are met, the employee may accept the legal services. Slide 26, please. And I wanted to mention also that as with the LEF trust process, there are also mandatory recusal requirements for employees who accept pro bono services under Subpart J. So specifically, any employee accepting pro bono services needs to recuse from party matters in which the employee knows that either a pro bono legal services provider is a party or represents a party from the time the pro bono legal services provider begins providing services until 2 years after the date they last provided. That applies both to the law firm or other legal services provider and the attorney themselves. And then in addition, if that 501c3 organization is paying for an employee's legal expenses, this recusal applies also to that 501c3 organization. So each one of those three would, the employee would have a recusal from. Slide 27, please. So that covers and concludes the substantive portion of today's training, but we did want to point out the resources that will soon be available to you. On legal expense, on the pro bono service aspect of the legal expense fund, we have 2 legal advisories right now, LE 2305, which provides a general overview of how the regulation operates, and LA 2307, which provides guidance specific to the solicitation and acceptance of pro bono services. We do expect to provide additional training and resources on pro bono services as this portion of the new regulation is used, but that will likely be down the road, but keep your eye out for additional trainings. We hope you find these resources helpful. And next slide, please. Please do not hesitate to reach out to your OGE desk officer if you have any questions about the new legal expense fund regulation, and we hope you'll join us for these additional trainings that we have planned. Thank you very much.